Assalamualaikum and good day everyone, especially to Dr. Saslina. Today we are from Group 7 going to present our topic for today, which is winding up. Our group consists of 5 members, which is me myself, Alia, followed by my fellow members, which is Nur Hanani, Nur Dayana Haifa, Nurul Izazakia, and also Yoga.
Winding up. Okay, what is winding up? Winding up is the process by which the assets of company are collected, debts are paid, and any surplus that incurred will be distributed among its member. Okay, for your guys' information, winding up also is known as liquidation. Reasons of winding up. Okay, in this slide, there is 4 reasons of companies winding up. First is the aspirations of company's life as stated in the company's constitution. Second, where the company is insolvent. Third, when the members of company want to realize their investment, which means the members of company want to get back their investment. And fourth, the reasons of winding up because it is ordered by court. So, under the provisions of Section 432, Subsection 1, Companies Act 2016, there are 2 ways of company winding up, which is first, voluntary winding up and compulsory winding up. Voluntary winding up. Okay, voluntary winding up is starts by a passing of special resolution by its member to wind up the company. So under Section 439, Subsection 1, a company may be wound up voluntarily if uh, A. The period fixed expired, or the occurrence of an event that the Constitution allows the company to be wound up, and the company has passed a resolution in a general meeting to wind up the company voluntarily. B. The company passed a special resolution to wind up voluntarily. So, what is the special resolution? A special resolution means that at least 75% of the company's shareholder agree to voluntarily wind up the company. Okay, and next under section 443 subsection 1 stated that in the company case of a company that having more than one director, the majority of the directors should ensure A. Make a written declaration that they have made an inquiry into the company's affairs. B. At a board meeting, they have formed an opinion that the company is able to pay off the debts in a full within a period of not exceeding 12 months after the commencement of winding up. Under Section 441, next under Section 441, winding up commences when A. At the date of the appointment of the interim liquidator is lodged with the registrar, and B. At the passing of a resolution to voluntarily wind up the company. Under the voluntary winding up, there will be 2 ways of winding up, which is members voluntary winding up and also creditors voluntary winding up. So, under members voluntary winding up, in the section 432 subsection 2 subsection A, it is when a company is solvent and a liquidator is appointed by the members during the members meeting. So, under section 445, appointment and removal of auditor, which is subsection 1, company shall appoint one or more liquidators for the purpose of winding up the company's affairs and distributing its asset in general meeting. Subsection 2, on the appointment of a liquidator, all the powers of the directors cease except so far as the company in general meeting with consent of the liquidator or the liquidator sanctions the continuance of all the powers of directors, which means an appointment of the liquidator will automatically make the directors of the company lose their power. The company stop carrying on its business, and the transfer of share are void unless there is the liquidator's approval of those transactions. Okay, next is the creditors voluntary winding up. Okay, under section 432, subsection 2, subsection B, okay, creditors voluntary winding up is happen. It is when a company is insolvent and a liquidator is appointed by the creditors during creditors meeting. So it will be known as creditors voluntary winding up if the company's board of directors fail to lodge declarations of solvency to the registrar of companies before a notice of a meeting to pass a special resolution is sent out to the company's members. Okay, creditors voluntary winding up, the continuance is okay. Under Section 449, Subsection 1, the company should have a meeting with the creditors in proposing for voluntary winding up. Next, Section 449, Subsection 2, which is the notice of meeting, which is both notice of creditors meeting and the company's meeting to pass the resolution for voluntary winding up to be sent simultaneously to creditors by post. Third, Section 449, Subsection 3, the company should choose a convenient time and place to convene the meeting. Which is under Subsection A. Notice should be posted to creditors at least 7 days prior to the meeting. And Subsection B, notice of the meeting should include the names of all the creditors and amounts of the claims that need to be claimed. Under Section 449, Subsection 4, the meeting notice should be advertised widely circulated local newspaper using the national language and English language. Under Section 449, Subsection 5, the directors of the company should, under Subsection A, issue a full statement of the company's affairs, which includes a list of the creditors and the estimated amount of their claims prior to the meeting, and under Subsection B, appoint one of the directors to attend the meeting.
Compulsory winding up is one of the way how company can wind up. Compulsory winding up is also non-court order winding up. The most common ground is the company's inability to pay its debt, where a creditor initiates the process by filing a winding up petition with the court. If a winding up order is made, the court will appoint a liquidator to oversee the liquidation process. This type of winding up begins on the application of one or more parties listed on Section 464 of Company Act 2016. So, as I mentioned earlier, the compulsory winding up can be happen when it begins with presentation of petition in the court. Under Section 464, Subsection 1 of Company Act 2016, the petitioners include the company, any creditor including a contingent or prospective creditor of the company, a contributory, or any person who is personal representative of a deceased contributory, or the trustee in bankruptcy, or the Director General of Insolvencies of the estate of a bankrupt contributory. Okay, the next, the liquidator. So lastly, under Section 464, Subsection 1, Subsection E, the minister on the grounds specified in paragraph 465, Subsection 1, Subsection D. Okay, in an application made to the court, the petitioner must state ground of application which has been stipulated under Section 465 of Company Act 2016. So Section 465, Subsection 1 of Company Act 2016 provide 12 circumstances in which the court can wind up a company. So A, the company has a special resolution resolved that it is compulsorily wound up by a court. Okay, the next, the company default in lodging the statutory declarations. C, the company does not commence business within a year from its incorporation or suspend its business for a whole year. Okay, lastly, D, the company that has no member.
The fourth element in the compulsory winding up would be relating to the Section 465 of Subsection E of the Companies Act, where this section states that the company should wind up their business when they are unable to pay their debts. Move to the subsection which is Section 465 of the Subsection F, where it states the directors have act in their own interest rather than in the interest of the members, or the directors were being unfair to unjust to other members. The court can make a winding up order if the directors have managed the company's affair in favoring of their interests instead of the members' interests as a whole, or treated the members unfairly. The most probable reason is that there is a breakdown or mutual trust and confidence and deadlock. Misconduct that concern about the conflict of interest and self-dealing transaction are usually the grounds for an application under this section. As the directors had act in their personal interest, this section also applies to a situation where the directors act in their favouring of another company in which they are also the director or shareholder of that company, as they have ignored the interests of the members of the first company. Then it is under subsection G. This section clarifies that it is compulsory to wind up the company when a fixed term of the company's duration has expired or the company's constitution has provided that the company is to be dissolved upon the concurrence of a certain event and such event has occurred. Next, it is regarding subsection H, where it states the court is of the opinion that the company is just and equitable to be wound up. This section will be elaborate more on the next part. The related case under Section 465 subsection H of the Companies Act would be the case of Ibrahimi versus Westbourne Galleries Limited. Ibrahim and Nazar become the only shareholders and directors in the company once the corporation took over the partnership. Later, the son of Nazar became a shareholder and director. Nazar and his son fired Ibrahim from his position as a director as a result of their major disagreement. The court determined that dissolving the corporation was just and equitable since Ibrahim's dismissal violated the common assumption that all members would be involved in its management. Additionally, the mutual confidence and trust also just ended.
According to Section 465(1)(I) Companies Act 2016, a company will be surely winded up if that company owned a license under Financial Services Act 2013 or the Islamic Financial Services Act 2013 and that license has taken forever or surrendered. And then Section 465(1)(G) Companies Act 2016 provides that a company will be winded up if it has carried on a licensed or accepted, received or taken bribes in Malaysia as against what is stated in the Financial Services Act 2013 and or the Islamic Financial Services Act 2013. Section 465(1)(G) Companies Act 2016 is about the company being liquidated from carrying out for unlawful purposes or any prejudicial purpose to or incompatible with peace, welfare, security, public interest, public order, good order or morality in Malaysia. According to Section 465(1)(L) Companies Act 2016, a company will be winded up if Minister has made a declaration under Section 590 of Companies Act 2016, which is the investigation of a company's affairs is at the direction of the Minister for Domestic Trade, Cooperatives and Consumerism, either by his or her own motion or on the application of members or debentures holders of the company.
So now I will explain more about just and equitable. Normally, for just and equitable, we will refer to the common law given by the court, and it gives a wide discretion to the court to make an order to wind up a company. There are 5 situations of winding up according to the ground of just and equitable. The first one is failure of corporate substratum. The second one is business carry on in a fraudulent manner. The third one is deadlock in management. The fourth one is operation. And the last one is breakdown of quasi-partnership. Let's go through one by one. So by referring to the section 35 clause 2 of Companies Act 2016, the company shall be restricted from carrying on any business that is not within those objects, and the company shall have full capacity and powers to achieve such objects, meaning that the company have the responsibility to produce or to carry on their business based on their objective. Okay, so we will refer to the case of German Dead Coffee Company, which is the fact of these cases is that the company was incorporated to work on a patent to manufacture a coffee substitute from dates. But unfortunately, it was discovered that this could not be done by the company anymore. So the substratum had failed as the company is impossible to carry on its objective. So the court held that this company should be winding up based on just and equitable. The next one is business carry on in fraudulent manner. Okay, we will refer to the case in Thomas Edward Brinsmith and Sons Limited, 1897. So for this case, actually, John Brinsmith and Son is a piano maker, but their employee was set up a company called Thomas Edward Brinsmith and Son Limited in order to manufacture pianos. This company was formed purposely to defraud John Brinsmith and making profit in a fraudulent way. So the court held that this company will be wind up according to the ground of just and equitable. Okay, so the third one is deadlock in management. So deadlock is a situation where there is no progress can be made anymore to the extent that the company could not function properly and there is no reasonable chance for reconciliation and also cooperation. We will refer to the case Yeniji Tobacco Limited 1916. For this case, there are two shareholders. Both of them are directors and both of them are friends. But unfortunately, they having dispute over their business strategy and they fell out and they couldn't get along, couldn't communicate well. So all the communication was going through the company secretary. Okay, so court decide that these two cannot work together anymore and the court held that this company should be wind up in the ground of just and equitable. So the fourth one is operation. So operation in a simple word is a lack of honesty in conducting the affairs of the company. This can be seen in minority shareholders always being treated unfairly by majority shareholders. We can refer to the case Lock and Anor v. John Blackwood Limited, where this company actually they failed to hold any general meeting to present their company's account to the members of its company. Okay, so this action were done in the purpose of enabling majority shareholders to acquire company shares at undervalued price. So this is an operation against minority members. So court held that ground of just inequitable will apply to wind out this company. So the last situation for just an equitable ground for winding up is breakdown in quasi-partnership. So what is breakdown in quasi-partnership is a breakdown of mutual trust and confidence of the members of the company to the extent that it restrict or it holds back the smooth running of the business and the company. Okay, we will refer to the case Lawrence versus Lorick Motors Limited 1948, where the court held that the company need to be wound out after the director of South African company, which was controlled by two families, committed adultery with the wife of the other. We know that this situation will actually break the mutual trust and confidence among the members of the company. So it will be wound out in the ground of just and equitable. So that's all from me. Thank you.
Section 471 Companies Act 2016 explains about the consequences of winding up, which is effects from a company's winding up. So, according to Section 471 Companies Act 2016, when a winding up order has been made or an interim liquidator has been appointed, no action or proceeding shall be proceeded with or commenced against the company except by leave of the court and in accordance with such terms as the court imposes. So what is the purpose of Section 471 Companies Act 2016? As noted by the court, it cannot be disputed that the primary object of winding up is the collection and distribution of the assets of the company pari passu amongst unsecured creditors after payment of preferential debts, and the purpose of the stated The provision is to ensure that all claims against the company in liquidation, which can be determined by the cheap and summary procedure available in a winding up, are not made the subject of expensive litigation. The provision is designed to prevent unnecessary multiplicity of suits which may result in dissipating the assets of the company. What is the end result from the process of winding up? So all pending legal suits against the company or stopping any parties from pursuing a legal suit against the company unless the court gives consent to the parties to continue their legal suit or bring a legal suit against the company. So second, when can such an application be made? When can we apply this section for 7.1? Post winding up order. So the clients can use, the parties can use, can make such application after post winding up order or where an interim liquidator has been appointed by the court to manage the affairs of the company, who can apply any pending litigators or any person who wishes to sue the company. So where can be this filed? In the court that granted the winding up order against the company. What are the things that should be taken note of while filing out the application? Should be served a copy of the application to the liquidator, and then a copy of the winding up order must be lodged with the Register of Companies within 14 days from the court make such an order.